and indeed non-lawyers to participate in trainings that are of interest. The faculty that we assemble are A-class, and the trainings are being offered for free. I'm sure you can understand that it takes quite a bit of time to put these things together. And so for the sake of what we want to do, we're trying to do, which is to have Nigerian lawyers empowered and competitive, I think it's important that we publicize the trainings that we do. And I think it's important that people also understand that these trainings, even after they have been offered directly during these presentations, are also stored on the MBA's YouTube channel, which is MBA HQ. You can access them for free at any time. Our preoccupation and priority is to see that Nigerian lawyers are equipped and educated. So today, it is my pleasure to introduce the tutor for today, someone I'm sure that you all know. She was here during the first edition, and her session was very well received, and I expect that today would even be more exciting, because the tutor for today is someone who consistently equips herself and gives a lot of knowledge every day. So it's my pleasure this afternoon to introduce Chinasa. She's an experienced legal practitioner with a track record of over 15 years in the field of intellectual property law, technology, media, and entertainment practice. Having worked in top Nigerian firms like Jackson, A.T. and Edu, Aluko Anoyebode, and Bao and Igodalo, she has advised in numerous local as well as cross-border and multi-jurisdictional transactions involving brand registration, transfer, commercialization, protection, and enforcement, particularly in Nigeria and other African jurisdictions. She also advises business owners on regulatory issues with particular reference to their IP rights. In addition, her experience across corporate and commercial law transactions, consistently ranked as an expert in the field of IP in Nigeria by Chambers Global Guide, and more recently, World Trademark Review 1000, World Intellectual Property Review Leaders, and Managing Intellectual Property IP Stars. Chinasa is an author and regular speaker on IP ancillary issues. She's an active member of many local and international IP associations, including the Pharmaceutical Trademarks Group, International Association for the Protection of Intellectual Property, the Anti-Counterfeit Federation Nigeria, Intellectual Property Committee of the Nigerian Bar Association, Section of Business Law, the Nigerian International Franchise Association, amongst others, as well as a faculty member of the African Franchise Institute. Chinasa has also served on several committees of the International Trademark Association, INTA, including the Africa, Middle East, and South Africa Anti-Counterfeiting Subcommittee and Trademarks Reporter Committee. Until recently, she was the Nigerian chapter contributor for the Inter-Country Guides on Trademarks, as well as a contributor to the Future Africa Forum on Development and Industrialization Issues. She had a master's degree in IP law from the University of Turin, Italy. WIPO has just completed her MBA with the University of New Brunswick, Canada, where her focus was on entrepreneurship and technology management. It is my pleasure, therefore, this afternoon to welcome and indeed to yield the floor to Chinasa Owana, who, by the way, is joining us all the way from Canada. Chinasa, I hope it's not too cold out there at the moment.
No, it's not at all.
Okay, welcome. The floor is yours.
Thank you very much, Sabina. It's a pleasure to be here, and I'm quite excited to be part of this training again, because I think it's very useful and very important that not only for us to know about other areas of the law, but for intellectual property, which is something that is not so common, particularly in other parts of Nigeria, apart from maybe Lagos, Abuja, and a few other cities. So it's a very useful thing for us to have today. Is someone sharing my slides, please? Okay, thank you so much, Nita. I'm going to be speaking today on the topic, the role of the intellectual property lawyer in the 21st century. It's not a very, it's not a topic that I expect to take very long, and then I also don't expect that at the end of today, would all totally understand totally understand the role that intellectual property lawyer will play, but at least we would have an idea of what it is, that an intellectual property lawyer does and how we as lawyers can, get involved in this area of the law. Next slide, please. The outline of my presentation is goes as follows. We will discuss the objective of the presentation just so that we can be clear. Definition of intellectual property. I'm not going to spend so much time on that because the previous speakers have done a very good job of that. We'll just look at briefly types of intellectual property rights. And then the bulk of our conversation would be about who an intellectual property lawyer is and what his role is. We'll have a recap and opportunity for question and answer. So the objective of this presentation is to help us understand the important role of an IP lawyer in the 21st century. An IP lawyer, that is an intellectual property lawyer. The role that we play in the 21st century, and it's very critical that we have, I'm glad that we have that aspect of the 21st century, because the fact is that things have evolved from what it used to be in the past, even not just for intellectual property lawyers, but generally for all lawyers, what we considered to be the role of the lawyer has changed, has evolved over the years, particularly in the 21st century. And we all need to be prepared to be able to seize the moment and be relevant as such. Next slide, please. On definition of intellectual property, even though I said I'm not going to rehash what has been said, it's good or it's needful to just run through this, particularly for those who unfortunately couldn't join us on the previous 2 days. So intellectual property simply refers to creations of the mind. When you talk about inventions, literary artistic works, symbols, names, brands, designs, anything you come up with that is used in commerce, right? But has come as the creation of the human mind. So it's intellectual in the sense that it comes from your intellect, right? It's not naturally occurring. It's not just something that exists in the state of nature and all of that, but it takes a bit of, thinking, a bit of intellectual, or cerebral input, for it to be a creation of your mind. So all inventions in all fields of human endeavor and all other rights resulting from intellectual activity in the industrial, scientific, literary, or artistic field. This definition is from the World Intellectual Property Organization. Next slide, please. In this page, I've just tried to give an overview of the various types of intellectual property that we have. We have trademarks that protect names, signs, symbols, and so on used in business in some jurisdictions. It also covers things like smell, sound, and all that. Patents that covers inventions, grants given by the government for inventions, domain names. You have all the .org, .com, .net, .gov, .edu, and so on. Artificial intelligence that deals with technological development, the robotics, and things like that. Integrated circuits, trade secrets, copyright, geographical indications, and appellations of origin that try to indicate where products come from, the source of products, and things like that. All of these are various types of intellectual property. And like I said, they're intellectual because they're intangible. They're cerebral. They're not things you can really hold on with your hand. I like to tell people that if you go out and say, oh, Mr. A married Miss B, this and that, you can ascertain the parties to the marriage. If you have a matrimonial court or whatever, if you're talking about, landed property, sale of landed property and everything, you can go and view the land, see the land and measure it is from this point to this point and all of that. When it comes to IP, it's it's intangible because you're talking about, oh, somebody sang a song, somebody wrote a book and all of that. And people are wondering, what's the IP in that? Or you have a brand name, Coca-Cola. What's the wonderful thing about it? You can't hold Coca-Cola per se, the word Coca-Cola, but it's a brand that is used in business. That's what intellectual property is all about, right? Like I said, previous speakers had talked about this extensively, Professor Shodipo and Mr. Gaba, so I'm not going to rehash that. I will quickly move on to our own topic. Next slide, please. And so the first thing we want to look at is, who is an IP lawyer, right? Who would you consider to be an IP lawyer? In Nigeria, we go to the university, we go to law school, we're called to bar, and we come out baristas and so the Supreme Court of Nigeria, thank God, and all that. We're all lawyers and we're in the field, and then it's like the whole world is before us, right? After law school. And people find themselves going to various, areas, mergers and acquisition, energy law, this one, that one, and all that. But most litigation and so on, most times everybody does like almost everything. At least the young wigs or new lawyers, we do everything, But then gradually, you find out you start to specialize in a particular area. For most people, I know that there are some law firms that once you start, you're put straight into a particular department or a particular field. But the general thing, at least for the majority, is that you do everything. And you're qualified to do so if you're a lawyer and you say, oh, there's one brief so and so place, you run and go and do it. But who is an IP lawyer? Who would you consider an IP lawyer? Are you an IP lawyer because you filed one trademark last year for someone? Would you call yourself an IP lawyer because you advised on some patent drafting thing, some years ago, or you have some technology thing that you're working on and all of that? Well, in this case, my own definition, and this is my definition, is that an IP lawyer is anyone who works in the field of intellectual property. So whether you're in-house, working as an IP manager, like we do, with MTN, or you're working in a law firm as, a lawyer in the firm and in the intellectual property department, or you have a lot of intellectual property briefs that you're dealing with, or you're working in a research institute or a university or something like that, and you're dealing with intellectual property issues, inventions and things like that, R&D, or you're working with the government, like we have some lawyers that are in the patent and trademark office in Nigeria, in Abuja, and so on. As long as you work in the field of intellectual property, you'll be considered an IP lawyer, right? But then it's a very tricky thing, because many people come up and say, oh, I'm an IP practitioner. I've seen some, I'm an IP enthusiast or something like that, but I'm an IP this. It takes a lot for you to be an IP lawyer. And contrary to what a lot of people think, it's not a no-brainer kind of thing. Because for you to be an IP lawyer, you must have certain key skills, right? And I would try to just quickly talk about these key skills before we go on to the role because of our time. The first one is technical knowledge, right? I just saw something from that. Please post, and if you have any question, please post it in the question and answer section as we go on, and we'll try to address that at the end of the talk. I'm trying to rush a bit because I don't have so much time. And again, I speak a bit fast, so please bear with me. The first thing I'll talk about, like I said, is technical knowledge. Technical knowledge deals with the content of what you are doing, right? For you to be a proper IP lawyer, you need to understand intellectual property law. It is a very simple area of law. Again, it's a very technical area of the law, and if you approach IP issues, the way you approach issues generally, then you might make a mistake or you might miss it. So you need to understand the various IP laws that we have. What's the position of the law with patents? What's the position of the law with copyright? What's the position of the law with what's it called? With trademarks and so on. And I'll try to give a practical example. Generally, we would say that, oh, if so for instance, I know for employment law and all that, if you're working generally speaking, if you're working for someone and you produce something in the course of your employment, that work or whatever you've produced belongs to your employer. when it comes, if you bring that approach to intellectual property or maybe to copyright, you'll be totally off, because when it comes to copyright, in the absence of a written agreement or a license or something to that, in the absence of anything written down, right, transferring the rights to a work, once someone has created a qualifying work, I mean, a work that can say that there's copyright, it belongs first to the creator and not to his employer, whether it was done in the course of his employment or whatever, or doesn't matter, unless there's some sort of written, agreement or written thing to the contrary. So that written thing could be in the employment contract, for instance. It could be an outright assignment of IP and so on and so forth. The point I'm just trying to make with this example is that you don't approach intellectual property the way you would approach every other area of the law. So whilst it's a very simple and straightforward area of the law, as you must have heard over the last 2 days, it is still a very technical area. And so for you to be a good intellectual property lawyer, you need to pay attention to what the law provides, know what the various laws provide. And then again, I'm sure, like I said, IP cuts across so many things, like apart from the things I mentioned, AI and artificial intelligence, patents, trademarks, copyright, and so on. You have the areas, the fields of technology, cryptocurrency, and media, entertainment, and all of that, with their specific laws, rules, and all of that. If you want to be an IP lawyer, then you have to take out time to understand IP, take out time to know what the law says and all that. My role today is not to get into all of that in details, but to give you, speak to the practical issues about how you as a lawyer can handle this. Again, you have to have analytical reasoning. Not everybody can be a good IP lawyer. You have to be able to analyze issues when they are brought before you. Because the thing about it is that you would deal with, particularly if you're talking about patents, for instance, right? If 2 or 3 people come up with an invention, how do you determine who the rightful, inventor is? Who is the person that came up with the invention? If let's say 2 companies come together to work together in a joint venture and they invent a product and all that, what would you see? There are issues about the IP that was brought from one company, and then the IP that was developed together. You have things about IP that belongs to company A, IP that belongs to company B, the background IP, foreground IP, and things like that. You need to dissect all of these issues one after the other to be able to know who to apportion what rights to and so on. I don't want to go into much details into that, but the point, suffice it to say that you must be very analytical in reasoning and not just say, this is how it happens in normal life and all of that. You have to have good drafting skills, particularly for those who are drafting things like patents. Again, IP involves a lot of drafting. You fill out all sorts of forms. You draft from opinions to advisory to drafting, like I said, for patents, claims, and so on and so forth. You cannot be a good IP lawyer and have an issue with communication, with writing, with drafting, and things like that. Having is the other point about strong communication skills. But in terms of strong communication skills, this goes beyond, your writing and all that, to also how you would meet and speak with your clients, handle issues that are brought before you, understand what they're saying. When, there are many times people will come up to me and say, I need to file a patent. And by the time I sit down with them and we talk, realize that what they actually have is not patentable. In fact, it might actually be in the field of trademarks or even copyright or something else. And so if you're not able to, like I talked about analytical reasoning, you're able to dissect the issues and also communicate very well with the person that you're dealing with, you run into problems because you'll be going to help the person secure the wrong rights. Again, if you don't even understand, you're not able to communicate well with your client to understand what it is that they're doing, you will not be in a position to advise them well, right? People come up, I've done some due diligence and exercises with some companies and all that, and realize that they've had a lot of IP, they've left a lot of IP on the table. In fact, they've let their employees walk out the door with their IP, right? And so that's as a lawyer, you should be able to have the skill of, being able to identify this is what your IP is, this particular thing is your trademark. This is a trade secret and all of that. Again, back to talking about analytical reasoning and all that. When it comes to IP, there are so many types that we talked about in my previous slide, but then you should be able to advise your clients as to what should be registered, what is the best form of protection for the kind of IP that they have. So for instance, if you have something like, let's look at the field of pharmaceuticals. If the client comes and tells you, oh, we invented so and so, we've come up with so and so, the cure for COVID, for instance, and all that, and we want to keep it as a trade secret. Keeping it as a trade secret might be a good idea, right? However, it may not be the best protection, because if they start producing that drug or whatever it is, whatever solution that they've gotten, right? It's very easy to take it to the laboratory and reverse engineer it and something like that, and find out what the constituent ingredients are and all that. I'm not a scientific person, but for those that are in the scientific field, they'll be able to do that and easily come up with what the constituent ingredients are and come up with a prototype or something like that. So it's very important to know that in that situation, perhaps patent protection might be the best option and not trade secret protection. Because for trade secret protection, you need to keep it secret. You need to keep whatever it is that you have secret, right? And it's also difficult to keep it secret because if you have a lot of people working for you and all of that, you might have to disclose certain things. And once it's disclosed, you lose that protection that you have. Whereas for a patent, where you disclose everything about your patent, your claims, what it is that you've done in exchange for protection. So when you have so patent protection might be the best thing you have to offer a client in the pharmaceutical field, and again in the technological field and all that. It may not be the best for some other sorts of things. So for instance, if you have, how would I give an example now? Well, it may not be the best for some other type of products that you'd have. I hope that point is clear. So you should be able to know what is the best form of protection, or if you like to use a combination of various types of protection for your client, IP protection for your client. You should also have strong negotiation skills. In business or in commerce, there will always be times where you may have to give or take, and sometimes your IP becomes your bargaining tool. If we're going to assign so and so product to you, I'm going to license the use of my trademark. Maybe I'll license it for 5 years, 4 years. I'll license it exclusively, or it may not be exclusive. I'll license it in a particular jurisdiction or not, and things like that. So you find that for IP, you will always be faced with situations where you have to negotiate. Again, when it comes to things like infringement and stuff like that, you would also have opportunity or reason for you to negotiate, with the other side and all that. And, it might lead to dispute resolution and things like that. But these are skills that as an IP lawyer, you must have. If you don't have these skills, please go and face another area of the law, another field to practice. You must be very organized. IP involves and pay attention to details and timelines. IP involves a lot of timelines, right? Excuse me. You have things like priority. Priority is a very, very important issue in IP. Who filed first, right? Particularly in a jurisdiction like Nigeria that recognizes the first to file IP. In some other jurisdictions, it might not be so, but Nigeria is one of those jurisdictions that recognizes the first to file IP. But so for instance, something like a trademark, right? Of course, there'll be exceptions, but generally speaking, the first person to file the trademark is regarded as the owner of the trademark and is recognized by the law. The burden now shifts to the other side to disprove that person's ownership, right, and all that. If you're not paying attention to things like timelines, when was this filed, when should this be renewed, when is the deadline to do this, for things like foreign priority, for convention applications and all of that, you need to be able to remember, oh, after 30 months, I need to file this, when is this entering the national phase and things like that, right? So these are very, very key skills that an IP lawyer should have. I'm going to just run through them again. Technical knowledge, excuse me, that's knowledge of IP first of all, and then possibly knowledge of the field or the field that you're dealing with. So there are so many fields, scientific, artistic, and things like that. You should have technical knowledge of that. Analytical reasoning, able to dissect issues and understand reason and know what, kind of preempt what's going to happen if we go this way, what will happen if we go that way. You need to have good drafting skills. You need to pay attention to details and timelines. You should have strong communication skills, negotiation skills, and you need to be thoroughly organized. So it's a lot of hard work to be an IP lawyer. Next slide, please. So having said that, and I will just quickly run through this slide, which should be, we should address the main issue that we came to talk about today, which is the role of the IP lawyer. Mindful of our time, the first thing I'll talk about is legal advisory. As lawyers, we are called to help our clients, handhold them, help them with their business, with their lives, and all of that. As far as IP is concerned, one of the major roles an IP lawyer plays is the provision of critical legal advice on a wide range of issues, a wide range of IP issues, like I talked about when I was discussing the skills that an IP lawyer should have. So you need to be able to advise a client on, first of all, which is the next thing I talked about, IP registration and maintenance, brand management. What is your IP? What are your IP rights? How can you protect these IP rights? How can you make it valuable to you? How can you, as a client, even for people, for instance, for those that are into production, manufacturing and everything, and they have a product that they want to take to the market, how do an IP lawyer is critical from the word go, like from the get-go. You should be able to tell the person, handhold them basically, right? And advise them on even such things as choice of a name, choice of color, branding, and all that. And obviously any other issue that falls out from any IP transaction or IP matter or product that the person has. IP registration and maintenance. This is very critical again, because in the past, the IP lawyer was known as just the lawyer that does filings, right? And you talk about IP, you say, oh, that person that filed the trademark, or how to file a trademark, or how, in fact, it was not just filings, but how to file trademarks. People didn't even refer to things like copyright, patents, artificial intelligence, technology, media, entertainment, and so on. It was mostly relegated to the field of trademarks, and it was just about filing trademarks. And then the only thing about an IP lawyer when you talk about registration, well, these days, you don't even have to be a lawyer to be able to file a trademark, right? So that's not just the role, that's part of our role, but that's not just the only role. Because you find people that have been registered as agents and they're able to file trademarks for people, right? And it's not just in Nigeria, all over the world. You have trademark agents that are not lawyers. But then an IP lawyer should also be able to file trademarks, file patents, file whatever IP it is that it needs to be registered or deposited, as the case may be, right? And then to also maintain it. Maintenance is where you talk about things like filing changes, recordals, renewals. Excuse me, please. Renewals and things like that. If there's any change in title, if there's any assignment, license, and so on and so forth. Again, an IP lawyer should be able to prepare and review all sorts of IP agreements. And there are so many types of IP agreements. I can't even begin, because in each field you have, so if you talk about, let's say media and entertainment, you have things like distributor agreement, production, co-production, sponsorship agreement, influencer agreement, and things like that. You go to the field of, let's say, patents, inventor agreements that deal with the inventor, licensing, technology agreements, and so on. Go to trademark, branding agreements, co-branding, trademark license, so there are a whole lot of IP agreements, right? And that's what an IP lawyer can do, right? You can help your clients review the agreements, again, to check that their rights are being protected, to check that they're getting the better part of the deal in any transaction or any negotiation and things like that. IP lawyers also conduct watch services and are involved in enforcement. Watch services just simply means looking out for your client, checking to see that that their product or their IP is not being infringed, by anyone. I joke about it that anytime my family and friends, anytime I go to the store or anywhere to buy anything, one of the first things I do is I pick up, I want to know who made this product, where is it from, which country, this and that, and all that. Because I'm so used to knowing who is behind this, what's the source of this product. Oh, this is a beautiful name, this is a very nice trademark that goes with this and all of that. And also looking out for your clients. There have been many times that we've come across, for our clients, infringing products just by going to Ghana. You want to buy, let's say you want to buy Nescafe, you see Mescafe, or you see Moscafe, or whatever. Or you might not even be the same kind of name, but you see the same kind of colors and all that. I remember one very popular beer that we saw. The name was totally different, everything, but the fonts that were used for the name of that product, the get up being, the whole packaging and all of that was identical to our client's own. Those serve as, and basis for things like oppositions, enforcement actions, and all of that. And as an IP lawyer, you have to be vigilant. So beyond perhaps going through things, something like the Trademarks Journal to see if anybody's any infringing trademark or something has been published, you have to be vigilant in the stores, in the market. You're working on the streets, looking around to be sure that your client's products or inventions or IP, not being infringed. And it could be as simple as a domain name. We've had issues where we had to go to NIRA, that's the Nigeria Internet Registration Association, to file for domain name disputes and things like that, right? Negotiations, dispute resolutions, infringement actions. So the IP lawyer is also involved in litigation. Now, personally, I didn't do much of litigation apart from before the Trademarks Tribunal, the administrative tribunal at the registry. But then there are people that do, like Mr. Gaba from yesterday, that do IP litigation, Mark Modi from Alukanebode, and a couple of other people that are involved in IP litigation, right? There are commercial IP transactions. So, an IP lawyer can just do transactions. I did a lot of IP transactions, due diligence, advisory, helping clients with M&A transactions and things like that, where you have IP issues that come up, sale of IP or sale of products that involve IP, and things like that. Technology transfer. IP lawyers also involved in advising their clients in technology transfer issues. In Nigeria, we have the NOTAP registration where foreign technology is being brought into the country and things like that, right? And then product registration. Product registration simply means that you have a product, maybe a new product, either like in the case of NAFTA, for instance, food or drug products or related items, or in the case of SON, every other product, technological product and stuff like that, that you need to register, right? It's the role of an IP lawyer to actually advise your clients and assist them with this registration. Now, I know that people might say, oh, no, there are agents that do this, yes, but it's for us as lawyers, we need to rise up to and take up our place, because we have a lot of, I'm sorry to say, charlatans and a lot of people who are not very versed in the law, assisting clients with this, and then when they have hiccups, when they now run to the lawyers to try to sort out these issues for them. And then again, anti-counterfeiting and anti-piracy. Regrettably, in Africa and Nigeria in particular, we have a lot of issues of counterfeiting, piracy, and all that. With the growth of Nollywood, and all, and even our music industry and all that, we find that a lot of our artists are not being paid all that that should come to them because of piracy. People say, oh, they're just trying to make a living, this and that. But the fact remains that the owners and the rightful, owners of this IP are not benefiting from them because it's been exposed. Because there are people that are, pirating their products. Counterfeiting is where you get where someone produces a product that is not, someone other than the real owner produces a product. So it doesn't matter whether the product that they produce is good. It doesn't matter whether it's even better than the original owner's product and all of that. The fact remains that it didn't come from the source. Now, it's the role of an IP lawyer to be involved in things like anti-counterfeiting. It involves a lot, and that involves a lot, like writing cease and desist letters, going after the clients, conducting market investigations, and things like that. So the point I'm just trying to make is that, and I hope at least I can, if I'm able to pass this message across, then I would have achieved my aim of this presentation. There's not a lot of time to go into all these in detail, but basically to say that an IP lawyer's role is very critical, and it goes beyond just, filings and running around and all of that. There's a lot more to it. You have to be on top of your game. In fact, if you're not a very cerebral person, you cannot be a very good IP lawyer. That's simple as that. Because you have to be very cerebral, you have to be very organized, you have to be intelligent, in fact. You have to be able to be analytical and all that, to be able to advise your client properly, help them, handhold them through the various stages of their business, from innovation to commercialization and all of that. And it will surprise you to know that there's a lot of work for IP lawyers out there, just that we're not really maximizing this thing. A lot of clients, a lot of companies, a lot of businesses don't even know that they have IP. It's amazing. Some very big companies that we hear their names every day, by the time you now go to maybe to do an IP due diligence for them or sit down, realize that they have a lot of IP that they have. I can't mention names, honestly, but they have a lot of IP that they haven't even addressed. They haven't even tried to harness. They've not even identified. They don't talk of harnessing it and protecting it and all of that. So there's a lot of work for an IP lawyer out there. The role that we play is very critical, like I said, and I'm still saying. And it's a very interesting thing because I don't know for you, but depending on people that are interested in new developments and all of that, 1 minute you can be dealing with electric vehicles. Another minute you're dealing with a musician and a new song that was released. Next minute you're dealing with someone that wants to register a trademark or register a product at NAFDAC. The next minute you're negotiating some license agreement and all of that. And next minute there's a product. It's a field that cuts across life. I keep on telling everybody, IP is like your life, because from the bed you sleep on to the water you drink, the bag you carry, the shoe you wear, the car you enter and everything, they are all products of intellectual property. And so there would always be something, there would always be an issue, a dispute, something to be done, something to get to advise someone on. Even when you have the big M&A transactions, there are always IP issues to be dealt with, because the name of the company, for instance, is their IP, right? The product, whatever product company is involved with, the IP and all that. And if they're going to have any, either it's a sale or an acquisition or whatever it is, you will need to deal with the IP issues as well. I can see my time is up, so I will just quickly run to the conclusion. One of the, and that's I want to just read out a quote by Peter Carroll, who's professor of law and director of IP at the New England Law. He said, "One of the great things about IP law is how varied it is. When I was a full-time IP lawyer, I could spend the morning trying to help a winery protect its brand in Europe, and then the afternoon helping an artist respond to a cease and desist letter from a brand owner trying to censor that artist's work." And that just goes to what I was saying about it's an interesting work. It's an interesting field, and an IP lawyer is someone that's, if you're passionate about this, you will thoroughly enjoy, working as an IP lawyer. And like I said, an IP lawyer's role cannot be overemphasized. I'm going to stop here for now. Thank you very much.
All right, thank you very much, Chinasa. I will just stop sharing our screen so we can go to the Q&A section of this webinar before the next speaker comes on. So we'll be able to do Q&A for at least the next 10-15 minutes. So just to go into it quickly, so I'll just respond. I'll just be reading out the relevant questions, because some of them, are really not something we can take on this call. People asking to be mentored, people asking if the MBA has an IP unit. We really can't. Okay, so the first question I will take now is, by your definition of an IP lawyer, can law teachers in the various Nigerian universities be situated within the conceptualization?
Sure. We have a lot of IP. Professor Bankole Chodibo is an example. He teaches, I think, in Bangkok. I'm not quite sure which school.
Yes.
Yeah. Yeah, field of IP. We have lawyers in. I know a couple of IP lawyers that's lecturing in Unilag and Nigerian, where we had a copyright what's it called again? Copyright X course, NELS and all that. So there are lots of IP lawyers, teachers who are lawyers, IP lawyers. Sorry.
Okay, so one person is asking a question on IPO, which we can't answer here. But the second part would be, what are the steps through procedures for trademark registration?
Okay, that's not the gist of my my talk today. And I know that Simi is going to be talking about that shortly after. She's going to be dealing with but I can just quickly run through if you want. But
no, let's leave it for Simi to deal with, since we have other questions I would like to take. So the next question is, the TMA Trademark Act provides that a trademark is assignable independent of the goodwill of the business. Can you shed more light to the applicability of this provision? Or it didn't really relate to your presentation. It related to Mr. Gaba's presentation. So, okay, so how do we clearly differentiate between patent, copyright, and trademarks? This person was related.
A lot of these questions are not flowing from my topic, which is the role of the IP lawyer, but I can just quickly answer a few of them if you don't mind.
Okay.
Okay. So in terms of patent, copyright, and trademark, like I said, there are different types of intellectual property rights. I didn't really explain them in detail, but a trademark, it's simply a name, a logo, a symbol, a sign, that you use to differentiate your business from another person's business. I think that's the simplest example I can give. And I also mentioned that in some cases you have things like even sound and color and stuff like that. So if you say Coca-Cola, for instance, and you say Pepsi-Cola, right? Those are two different names. They are identifying a type of cola drink, a type of soda drink, but the names would let you know who has which one. I usually give this example when I talk with students I am teaching, that if you go to your village for traditional, not poolside village or village, like inside the hinterland for a traditional wedding, right? And someone goes around the room with a glass with glass of darkish drink, orange, let's even say orange drink, goes around the room and is offering it to people. Would you take it and drink? Let's say an old woman tying a wrapper is just going around and say, hey, everybody drink, drink, drink. Probably wouldn't. But then if you go to that same traditional wedding, you don't know anybody, and that same old woman is going around with cans of Maltina, Pepsi, Fanta, Coke, and all whatnot. You probably grab it and drink if you're very thirsty without even thinking twice. And the reason for that is that you've seen the name of the company. That's what a trademark is. A trademark identifies the product. If you're driving down Awolowo Road and you see a very big orange square, you're looking for a bank, you immediately think Guaranty Trust Bank, GTB, and not First Bank, because that color has attracted you. That's their brand. That's what a trademark is. So it's a name, logo, color, whatever it is that identifies one business from and differentiates it. Why you will buy an LG and not a HP, and so on and so forth. For copyright is, it's in the field of artistic, cinematographic, dramatic, and so on and so forth. It's kind of a negative right, a right not to copy, right? When you have a qualifying work. So if you produce a work that is original, and it's fixed. What does original mean? That no one has done it before, it's new, and it's fixed. There's a medium you can see it on, either it's in a book, it's in a tape, it's written down somewhere, or whatever, right? And it's in this field that I've mentioned, artistic, literary, and so on and so forth. Then that's what copyright covers. Patents is a grant for the government for an invention. When you produce something, and you disclose your invention to the government, in exchange for that, you're given a certain number of years to exploit your product, right? Or protection, So in Nigeria, it's typically it's 20 years. In some jurisdictions, it's more than that and might be less than that, but typically 20 years. In Nigeria, it is 20 years. You have a period of 20 years to have exclusive rights to that. So you've come up with an invention, whether it's in the pharmaceutical field, technological field, or whatever, and you tell the government, oh, these are my claims. I'm claiming that I'm the one that discovered the cure for COVID. I'm claiming I'm the one that discovered autocorrect in telephones or whatever, right? I'm just trying to make this as simple as possible. And in exchange for that, the government says, okay, you know what? You're granted a patent for this. Nobody else can produce this. Nobody else can exploit this for this period. So if you look critically at this, you realize that sometimes you could have more than one IP right in one product. You know, even though they are different IP rights, they protect different things. I'll stop there so that I don't keep going on and on.
Okay, so I've seen a question that relates to your topic, which is what are some of the challenges IP lawyers face and how does one avert them?
I would say the first challenge an IP lawyer faces is even maybe from experience, from within, right? When I say within, from our fellow lawyers. And well, apart from lawyers, from most people, because people find it difficult to understand or appreciate what you're doing. I've worked in places where people say, come and they ask me, what do you even do? What do you really do? What's your role? What's your job? Like, you come to work from morning till evening, and what is it that you're doing? I see you, because like I said, IP deals with intangibles. There are things you cannot hold on to. So people don't really understand it. They don't fully appreciate what it is that you're doing, what your work is or your role. I think that's the biggest challenge. So when you're even trying to explain, oh, this is the value I can give you, right? It's a challenge because people don't understand, first of all, IP, so they don't understand what it is that you're doing. That's one challenge. And so again, and because they don't understand the value you're bringing to the table, they find it hard to either accord you a certain value. I don't know if that makes any sense, or to even pay you for that. That's a challenge. But again, I'll be quick to say that that's a challenge that we face in Nigeria and a lot of African countries. In other jurisdictions, people don't play with their IP lawyers because they realize that if they're going to be kept out of trouble from the beginning of their business, from, like I said, from production to going to the market, commercialization and everything, they need their IP lawyers, by their side. So that's one. What other challenge would I say? Keeping, like I said, you need to be organized and all of that. So you need to be very, very on top of things. So sometimes it's a challenge to maintain all the due dates, remember timelines, or you need to file by this. But then there are a lot of IP software that could help you with that these days. So that's not such a challenge like that anymore. Yeah.
Okay. I'm just trying to see. So another question is, can you establish an IP practice excluding IP litigation?
I'm sorry, I didn't get that.
Can you establish an IP practice excluding IP litigation? So can you have an IP practice without having IP litigation?
Certainly you can. I know lots of people who do that and they farm out their IP litigation. So when you say IP litigation, that's so it's clear. IP litigation before the formal courts, right? Because we have IP tribunals, and I don't know how. So, for instance, if you're representing a client and client has an opposition matter, or so you say you're not going to go and represent the client in opposition. If you give out your file, then he's basically giving out your work because it's part of the process, right? In terms of, maybe a full-blown matter that has gone to the Federal High Court and all of that, I know lawyers that farm that out to others to handle for them and focus on just the transactions, filings, and things like that.
Okay, so I'm just trying to make sure that, just find the questions that are relevant to us because we just have 6 more minutes. So interesting question. It says, my question is, if who owns an IP? Okay, so the person is asking, what happens where a company owns an IP, owns, IP assets, and then the company is dissolved? So who would now own those assets after the company is dissolved? Who do you transfer those? It was just an interesting question.
Well, I guess in going through the process of dissolution, excuse me, all of those issues would be discussed or decided, right? If you cannot, just as a legal entity, if you don't exist, then you can't own something. It's as simple as that. So either the IP would have been transferred prior to then, or something like of that, or then that's it.
Okay, so very straightforward question is smell an intellectual property right in Nigeria?
It's what?
Smell.
Smell. No, it's not.
Okay, so so as an IP lawyer in Nigeria, how do you handle foreign IP clients who particularly reference to be? No, this is not a question for us. So a question was asked, how do we incorporate, what are your advice on how we're going to incorporate IP to university education? I think that's Professor Shudipo should have answered that question. And then please, can you name a few IP softwares that can help an IP lawyer?
I know of FileEye, Patricia, Anaqua. Those are the three that come to mind right now.
Yeah. I think she says, did you mention that there are some softwares that can assist in remembering and tackling the issues of timeline? Can you it's the same ones we've just mentioned, which is FireEye and Aqua, and all of that. So I think it is time for us to go on to the next speaker. Chinasa, do you have any closing remarks before we go on to the next speaker to take their presentation?
Nothing really, just to say once again, it's been a pleasure to be a part of this. Like I said, it's such a vast topic. Like in trying to put this together, I just struggled with what to say, what not to say. But I hope that I've been able to pass on a message, and as studious lawyers, we should go and read up and do some more digging. But suffice it to say that it's interesting being an IP lawyer. I've done that. That's what I've practiced all my legal career, and I totally enjoy it. And I think there's lots of opportunities, home and abroad, lots of opportunities. Wow, home and abroad for people. So it's important that people really look into, how they can be relevant in the field of IP if you're interested. And I'm also available. I don't know if my contact details were put up. If anyone wants to reach out, ask any question. I'm very responsive on LinkedIn and other social media. I would be happy to, even if I cannot answer you, I can point you to the right direction and all that. Thank you very much. Okay. And thank you, MBA.
Okay, just before I pass on to the person who's going to anchor the next session, I would like to say, just to add to what Chinasa has said, that the practice of IP is in the practice itself. You have to wake up every morning and that's all you do. Like for us, it's easy. It's easy for, we the practitioners to, these things come naturally to us now because that's all we do. We wake up in the morning and it's IP that we do. So in wanting to be an IP practitioner, you have to find, set up yourself in such a way that that's what you're going to do every day, so that at some point it becomes, first or second nature to you. It's IP that you're doing every day, and that's really, for me, practice makes perfect. And so I will hand over to Mr. Maiwa Owolabi. Maiwa, if you're here, please show.
Hi, I'm here.
Okay, so I'll just hand over to you to introduce the next speaker. Maiwa heads ICE continuing legal education for the MBA Lagos, and he will be taking the next segment of this training.
Thank you very much, Inta. Ladies and gentlemen, it's a pleasure to join you. I enjoyed that session thoroughly. Thank you very much, Chinasa. I'm sure we've taken a whole lot from what you've said. At this point, I would like to introduce to you the next speaker, She will be speaking on the topic, intellectual property, the basics. It's no less a person than Simi Oyelude. Simi is a partner with GLS and Co. GLS is one of the foremost commercial law firms here in Lagos. Simi is a partner in the firm, like I said, and our practice focuses on intellectual property. She specializes in IP prosecution and enforcement. Her practice includes advising on registrations of IP rights and IP contentious work for clients. She also advises on IP infringement cases and unfair competition cases. Similoloa is advising clients in a wide variety of industries, including leading financial institutions, multinational corporations, regulators, and corporates, both domestic and foreign. And the areas of specialization include telecommunications, technology, pharmaceuticals, hospitality, commodities, services, retail, and fast-moving consumer goods. Like I said, Shimi is a well sought after professional. She has several accolades. In 2022, the World Trademark Review recommended as a recommended individual for 2022. In 2022 as well, the Managing Intellectual Property IP Stars 2022 recommended as a leading practitioner in the field. In 2021, she was described as an emerging IP player and got the award at the conference Gorilla. In 2021, she was awarded a Rising Star Award for the category of 40 under 40. Ladies and gentlemen, please join me as we welcome the next speaker, Simi Oyelude, as she speaks on the topic, intellectual property, the basics. You're welcome, Simi.
Thank you very much, Mr. Mayo, and thank you, MBA, for inviting me to speak at the MBA ICLE conference. Thank you, Chinasa, for the very detailed presentation. It was really, really educating. Thank you very much. And also thank you to Professor Shodipo, Mr. Agaba, for taking out time from Tuesday, yesterday, to teach us on specific areas of intellectual property. And good afternoon, everyone. So please, can you share my slides so that we can start off, please? Or in the interim, I can try to share the slides.
Yes, please go ahead, Simi, since you can do it from your end.
Okay. So I don't know if you can see my slides.
Yes, we can see your slide.
Okay. So I would like to start with just something I read, something very recent, that talked about the international nature of intellectual property. So the good thing about intellectual property is sometimes your market is not just the domestic market. It could also involve advising your clients for the enforcement of their rights in a foreign jurisdiction. So for example, a managing partner of a very well leading international firm was asked the reason why they decided to open a law firm in the US. And he mentioned that when the technology companies like Meta, Google, and all that today started, they started from California. But as their business decided to grow bigger, as they decided to grow their businesses, they had to look for firms who had that international touch to the protection of their IP rights, transactions, and advising on every area of their business. So the world is global, in as much as we are all, or some of us are in Nigeria, some of us might be in Canada, or wherever we are. We should have it at the back of our mind that we have to grow skills that would enable us to be major players in the field. So for example, you have a company you are representing in Nigeria, or who is your client, who wants to do some work in Canada, the United States, the United Arab Emirates, Saudi Arabia. Companies are looking at getting lawyers that can actually coordinate these efforts. And one of the ways to be able to, one of the skills the good skills you have and you should have, and one of the skills you should seek is how to be able to represent clients by managing their intellectual property rights. So for example, a client will come to you to say, oh, I want to do something in a repo or API, and you actually don't know what to do. In that case, you would lose that client because one of the skills for managing such client or managing such portfolio is not there. So that is why I'm happy that we have like lots of participants today who are actually interested in learning about intellectual property. And I'm going to be breaking it down, maybe taking us back to some of the things that Professor Shodipo explained to us on Monday. So my focus today would be the first introduction, explaining the categories of intellectual property, the importance of intellectual property, the legal framework for IP in Nigeria, the importance of IP to individuals and businesses, registration of rights, so like the process. So if you want to file a trademark, what should you do? Because I've seen a lot of questions around, oh, what do I do if I have a client who wants me to file a trademark? The regulatory agencies in the space, and as we all know, questions and answers. So I'll go straight to the introduction. IP has existed since the development of civilization. So a lot of us, if we follow the news, we've seen a lot about the mummies in Egypt. There's been lots of civilization, the Egyptian civilization. Some of us have heard about the Industrial Revolution and all that. So like IP is the foundation of all this development. It has always been, when you invent something, there has to be some form of IPs in it. So like all the old mats we see on the walls that Egyptians used in building their pyramids, in solving their issues around the medieval ages, IP was actually involved. So like the first modern patent was granted to an Italian investor in 1421, marking the beginning of intellectual property. Maybe system, I would say intellectual property system, not IP, because I'm sure before 1421, we've had lots and lots of inventions because man has existed way before then. Like I said, I've talked about the archaeological findings in Egypt, and it has pushed it way back to at least 600 BCE. So what is intellectual property? We all know every day, every year, we hear about WIPO. And what is WIPO? WIPO is actually the World Intellectual Property Organization. And they actually are the agency or the UN agency in charge of the organization and management of IP for different countries or different treaties that we have today. WIPO refers to IP as the creation of the mind, everything from the work of art to inventions, computer programs, to trademarks and commercial science. And also it would be very, very wise to state that IP is divided into two categories. You have the industrial property and you also have the copyrights and related rights. IP is wide, but they have tried to differentiate it into these two categories. It encompasses different endeavors, both cultural, your economic life, and most of the things you see today. So for example, your COVID vaccine, it was actually someone who developed the vaccine. That is IP. The car you see today, even from the food you eat, the clothing, everything around you, is just as if IP is life. Like Chinasa said, everything from your shoe to your phone to your bags, everything you have has some form of IP in it, or all forms of IP in it. So like I said, WIPO divides IP into two categories. We have the industrial property and the copyright part. So when we talk about industrial property, we're looking at inventions, which are patents, industrial designs, trademarks, geographical indications. Copyrights and related rights relate to literary and artistic work, including performances and broadcasts. And I would just like to chip in here for purposes of just before we get to the Q&A. If you want to learn IP, you can also learn IP by attending webinars, but you have to just be hands-on. Every day when you wake up, there is always something to read on the WIPO website. So for example, WIPO website defines IP into 2 categories, and you have A to E. So you have the copyright, you have your related rights, you have trademarks, you have patents, you have industrial designs, you have utility models, you have plant and animal varieties, you have your performances and broadcasts. So when you get to the WIPO website, you are going to see the definitions. It defines it into 2 categories, but there's a very long division, that's A to E, and that will just give you a very clear description of what IP is. So let's go to patents. What are patents? Patents are like exclusive rights. They're like the inventions you find around. So for example, someone comes to you to say, I just invented a car that can fly. So it's a car, usually cars will move on the road, but someone decided to add some wings to theirs, and theirs the car can fly. So that is like something you've not seen before. So it's an invention, something that is new. It is inventive. So for example, now, if you want to file a patent, how do you, what are the things you are supposed to ask the client? So someone comes to you to say, oh, I want to file a patent, I have an invention. In your head, oh, I've never seen a flying car. That is it. But someone in Korea or someone in South Korea or someone in the US might have actually maybe gotten that particular type of invention and might not have maybe made it into a product or process. So for jurisdictions outside Nigeria, you have people you call patent attorneys. So patent attorneys are people who have a combination of the law background and the science background. So for example, some of them have backgrounds in biochemistry, some of them have backgrounds in product engineering, process engineering. So for example, what makes something an invention? When you say something is novel, it's not the invention. If a lawyer like myself, who doesn't have any science background or who doesn't have any engineering background, should see the process or product, I'll be able to know, once I know that this is not new, then it's not an invention. Maybe I see a printer and I print in my office every day, and he's doing the same thing that I do in my office every day. Then someone says, oh, I invented a printer that prints colored documents. I have colored documents in my colored printers in my office that can print documents in colored. So at that point, I know this is not, for me, a normal person, from a subjective or objective point of view, I know this is not new. But if, for example, whatever you're inventing, the engineer or the biochemist or scientist will see this, and immediately they are able to know, okay, there's some form of invention here. And how are you able to test inventions? So for example, there's what you call prior arts. So prior arts, some of the things I might be saying on this patents might not be some things that are related to law. They might be related to more for patent attorneys. So prior art searches are searches you conduct to know the state of invention as it is today. So for example, you have to check journals, you have to check with the universities to know what has been published by their scientists. You have to do searches in patent registries with WIPO to know the state of art. So there is actually a confusion to know whether the state of art is jurisdictional or international. And there's been a case to test that in Nigeria to know, okay, if I say I'm inventing something today, should it be the state of art? Should it be totally international or Nigeria? So that is how most patent attorneys are able to know whether something is inventive or not. So the state of art is, what is the state of technology as it is today? The state of technology in relation to agent banking, the state of technology in relation to POS, the state of technologies in relation to ATM terminal means you can swipe your card, use your card, and be able to get money. But there might have been like an improvement in terms of the state of technology, which I may not know because I'm not an engineer, but people who have gotten patents as an improvement on the state of technology for mobile banking or agency banking. If they conduct the searches in the registry, they will be able to know whether what you have is patentable or not. So that is how you are able to, patent attorneys are able to test inventions. They test it by conducting prior art searches on the state of art as it is today. So to get a patent, you have to get the technical information about the invention. What is it? What are the things that, what is it that this person is actually, what do they want to patent? So most times you have to ask loads and loads of questions. So in your head, like Chinasa said, you have to be very analytic. So you have loads of people coming every day to say, oh, I've seen this. Immediately you are talking to me. I'm already on the website or on internet checking, oh, but this thing exists. What is the difference between what you have and what this person have? So most times people will now be able to explain the technology. So sometimes it's not a new technology. It might just be an improvement on the technology. So that is how patents come in. And most times they are territorial. So sometimes you find people saying, oh, they want to file international patents. There's nothing like you want to file one patent that will cover you in all the territories. If you want protection in relation to your patents, even if you are filing a patent cooperation treaty under the PCT, you still have to enter your patent through the national phase methods. That means you need to file whatever patents you have through the PCT method. You still need to take it to each of the countries where you clicked during application to say, I want to enter my patent here. So patents are territorial, and in general, they're exclusive rights. So the rights you have over your process, the rights you have over your methods, they are very, very, very exclusive. Then we come to industrial property. Industrial property, we come to industrial design, sorry. It constitutes the ornamental aspects of an article. So sometimes it's not just the ornamental aspects. You have, like Professor Shodipo said, when you are creating something like, let's say, the shape of a Toyota Highlander, before you would see the final process, someone drew those shapes, someone drew those designs. You would always see it in, it's more like a technical drawing. You see it in sketches with biros and pencils. That is that sketch that they would now use to produce the final products. So your industrial properties are like three-dimensional features, the shape of your Coca-Cola bottle, even though sometimes it can be registered as a non-traditional trademarks. Most people would also register it. The shape of your shoe, sometimes bags, wristwatches. It's the industrial design covers a whole lot of things. So for example, in Nigeria, we have two distinctions. We have for textiles, we have for non-textiles. So most times when you want to file industrial designs, you have to indicate if you are filing your industrial design for a textile product or non-textile. So non-textile would always relate to your three-dimensional shapes and all. Then the textile would not relate to the shape, the textiles, the designs on the textiles and all that. I know someone asked a question 3 days ago on some jurisdictions, how they are able to differentiate between different rights. So sometimes you have an overlapping rights between industrial designs in some jurisdictions and industrial property. So for example, in some jurisdictions, once you are filing your product or process or shape or whatever under industrial design, you would not be able to go under copyright for artistic products. So for example, now this affects a lot of fashion designers when they are asked, oh, okay, I have this where I have all my designs and all that. So if you have like some jurisdictions, if you have more than 50 pieces, you cannot claim copyright over that particular product. They'll ask you to go straight to industrial design because you are the process of creating it industrially. Those are the things they are looking at. So once you have more than 250 pieces, they'll tell you, please, this is not coming under copyright. What we are looking at, it's industrial design. So in principle, the owner of a registered industrial design or a design patent has the right to prevent third parties from making, selling, importing articles that has a resemblance to your design or copying the design substantially. So for example, in the market, you find sometimes some products become generic, maybe in terms of color, in terms of shape. Maybe everybody in, there's this in 1996 case that would have been a very good case, but it actually never went to the end, where someone was the one who started using the red color for blood capsules or shape. Sometimes you have shape. Sometimes when you have this shape in the market, someone has actually registered it as an industrial design. But because industrial designs have a lifespan of 15 years, so maybe immediately when it lapses, it goes into the public domain, then you see people copying because that particular person who registered this design has already become well known in the market. Some people, when you start seeing the design, you feel, oh, this red color is actually for brake pads, red color is for red capsule, this shape is for brake. So sometimes it's actually there's actually a fusion between shapes and non-traditional trademarks for this part. Then we go to design, continue with designs. Like I mentioned, depending on the national law and the type of design, industrial design may sometimes be protected under works of arts for copyright law, but from some jurisdictions would not allow you. They tell you once it's more than 50 pieces, please just go and do the industrial design. Then we come to trademark. Trademark is a sign. We've heard the definition of trademarks over again. It could be a sign, it could be a smell, it could be a sound, it could be anything that helps you. An identifier is an identifier that helps you to distinguish your goods or service from the service and goods of other people. So, for example, it could be a letter, it could be a word, it could be drawings, it could be shape and packaging, like I explained. So, a lot of times, if you go through your trademarks journal, you get to see lots of devices, shapes. They are called non-traditional trademarks because at this point, they are well known in the market, and possibly the statute in that jurisdiction does not prevent people from registering it. So, for example, the Business Facilitation Act amendments enlarged the definition of what a trademark is, which now includes shapes. So before, maybe someone could raise an objection to say shapes are not registrable in Nigeria. This is a three-dimensional trademark. Please take it to designs. You can easily say under the Business Facilitation Act now, you can register shapes and packaging. Then we come to geographical indication. Is a sign like we heard on Monday, specific origin, like your Ijebu Gari, is fused. This is an identifier to say, oh, this particular product is from here. This is totally different from certification marks because that is just certifying that these products, and usually certification marks are used like across maybe associations who have registered it like in together, and usually everyone using the certification mark has been able to reach that particular stage to be able to use it. But for GIs like Ijebu Gari, you shouldn't have. So for example, let's look at champagne. So I did some case, I think about 8-9 years ago, where a Nigerian claimed they produce champagne in Nigeria. It's not possible. Champagne is only produced in the southern part of France. So that is actually where you have all these issues with GIs. You can only find that particular, because of the climatic conditions, it's like very, very, very a nice way of geography for producing such drinks, wines. You have cheese, then you have lots of these GIs in Europe. So someone in Nigeria saying, oh, I produced this in Nigeria, is not possible. Maybe you produced it there, branded it in Nigeria, but not saying, because the climatic condition cannot, or even the processes cannot help you to be able to produce such type of wine. So that was where the trademark registry started to say it's actually not possible to have these products brewed here or produced here because the climatic condition here is not even good enough to be able to produce this. So that is where you have things around GI. So you have spirits handicraft, industrial products. WIPO has done a lot around GIs. They've done a lot in Senegal around GIs. Like recently, there's this fruit, it's found around Nigeria, it's very sour. It's also in Senegal. The women came together to start producing and putting it in packs. It has medicinal values and they use it for teas and all that. And WIPO was very interested, and there was a lot of write-ups around these products. You always find it on Twitter. Just check WIPO GIs Senegal. You'll be able to see a lot they've done around these GIs. Hopefully, we'll be able to do something in Nigeria to protect our GIs. For copyrights, copyright helps protection around books, paintings, sculptures, computer programs, databases, advertisements, maps, technical drawings. So these are like things these are like rights that would help you to protect. So if you have your book, you don't have to register copyright in Nigeria. Once you've been able to show, I think the new act says some effort, not sufficient effort again, copyrights will annul. So works commonly protected by copyrights would be newspaper articles, computer programs, databases, artistic works like paintings, drawings, photographs. Copyright gives the author economic rights and moral rights. So your economic rights is the rights you garner from maybe the sale of your books, your films, the monetary right out of that particular work. And that is actually the rights you assign. So for example, now if you have a book and someone wants to adapt that book from English to Yoruba, from Yoruba to French. So you have to be able to license that right. And in the process of adaptation, you are getting money. The author is getting money from whoever seeks that adaptation right. So that's your economic right. Your moral right is the right to be named as the author of your work. So these are the rights that inure in copyrights. Also, in majority of countries, including Africa, Nigeria, copyright protection is obtained automatically, like I mentioned, without the need of registration or formalities, because the Berne Convention requires this. Is a treaty that Nigeria has signed and domesticated, so we have to actually abide by the provisions of that treaty. There also exist IP rights in plant varieties. So for example, if you create a new type of plant that can cure epilepsy, rashes, those are type of stuff that IP rights would always be involved in. So you even have like biological materials. So they are very, very, very important rights that IP inures in. It is also important to follow that there is an effective system of plant variety protection in Nigeria. There's a new Plant Variety Act, I think 2021. And for people who have like plant varieties protection, they can always like go there to seek such protections. What are the importance of IP to individuals and businesses? So for example, in Nigeria, up until when we now started having the technology boom and started having lots of businesses who are now thinking about their IP. About 10, 15 years ago, a lot, maybe mostly multinational and few indigenous companies actually had like the interest in protecting their IP. But now it's something people are actually thinking about. For businesses, IP is the foundation of your business, is the artery of the business, is the lifeline of the business. So if you have a process, if you have a product, let's say for example, a pharmaceutical company, we are selling a product that can cure cancer. For example, if they find a vaccine that can cure cancer and you decide not to patent, you decide not to trademark the name, you don't do anything, even if there's a plant variety involved in the mixture, nothing, and you just push it into the market. Like Chinasa said, people would always reverse engineer your invention and push it out in the market. And at that point, there's no business because nobody knows who sells what. You just have a product without a goodwill in the market, without a trademark in the market. You would not be able to go against infringers, even if you're able to go based on trademark. What happens to patents and the others? So IP helps in the protection of inventions, trademarks, service marks. it helps. That exclusivity gives you that 20 years, you'll be able to gather in all the money you spent on the research and development, and also be able to, if you have to license to co-parties and all that, legal rights gives you protection against infringements. Well, that is not 100% true, but at least you'll be able to go against infringers when they come for you. You know exactly, you have your certificates, you have your IP lawyers, and you can always go against infringers. Branding and recognition is another good part. Like, you already have your brand, you have it registered. So most times you see the R besides, people put their trademark and they put the R beside it. It's just a form of saying, oh, this is registered. So for some times it might stand as a deterrence to people who might want to infringe on the products. It's a source of revenue, like I explained, under copyrights, your economic rights, your trademarks, your IP portfolio. So for example, there are banks now where even the Startup Act, I know when it came out, a lot of people talked about how you can use your IP to secure investments. Well, using IP to secure investments is not something that is new. It has always been in existence. And I know there are banks who had always say, oh, I can use my IP to secure investments. So I think about 3 or 4 years ago, a well-known artist talked about a system where you use your IP to secure some money to be able to get money from investors to be able to do business. These are source of revenue. So if you have like a very strong IP portfolio, you can always use it as a source of income. So sometimes you'd see people doing away with some set of products. Sometimes they don't just let the trademarks sit there in the cooler. What they do is pull out some IP and assign and get some money off it. So for example, if you get online, just check top 100 best brands in the world, and you see some brands are worth over $1 billion USD, because this is like the lifeline of their business. Without that particular brand, there is no name. So that is like a huge source of revenue. So sometimes when people do IP valuation, it's more of an accounting thing. Maybe hopefully in the near future, we might be able to talk more about valuation of IP rights. How do you value your IP rights? How do you know what is what, your goodwill in the market? When some people value some IP rights, they'll be able to get a whole lot of revenue. So for example, lots of people don't know Nigeria has close to 200 million, over 200 million people, and you just have distributors who go to these countries, bring in the products, and the product is so big in the market. So for example, the foreign company who produces this product are not in Nigeria, but the brand, the goodwill is already so massive in Nigeria, even though they don't do business in Nigeria. So for example, if you have such a huge company who has such very, very, very lots of products in Nigeria like that, if you value that IP, might be even bigger than their revenue they have in their own country. It gives you competitive advantage, facilitation of international trade. The good thing for IP lawyers is you would always be valued. Your skills will always be valued in the IP space. You would always need, like, international trade is something big. We all know about the EU region. We have the AFCTA, which there's an IP protocol being drafted, or which has been ascended to. So like IP is a big part of international trade. So for you to be able to trade in some region, you need to have your IP registered. Recently in Kenya, you have to register your brands for purposes of anti-counterfeiting and all that with the customs. So these are like, it will always grow, and there will always be more work for lawyers as it comes. So what are the legal framework for IP in Nigeria? We have the Trademarks Regulation, we have the Merchandise Marks Act. Even though it's old, you have the Trademarks Malpractices Act, the Cyber Crimes Prohibition Act 2015, the Counterfeit and Fake Drugs and Wholesome Processed Foods Acts, the Plant Variety Act, you have the Designs Rules, the Patent Rules, and amongst others. So we talked about the Copyright Act. I know Prof talked a lot about the Copyright Act and the fact that we now have a wider protection for digital works. You have the audiovisual works, which is being explained a lot. You also have the Copyright Act, which helps to create access to creative works. And Nigeria is a signatory to a whole lot of treaties when it comes to the copyright regime. So you have the Nigerian Copyright Commission. It is the agency that is responsible for copyright. So if you want to do copyright work, you're not as a lawyer saying, I'm going to the trademarks registry. The responsible agency to go to is the Copyright Commission. So if you have like, then there's nothing like registering of trademarks, even though the Copyright Act allows the copyright registry to create a database that will be able to, when you have a database, it's easy to trace the works and works that has been deposited at the copyright registry. So what you have now is an electronic deposition system. So what you do is create an account, you deposit your work through that account, and a deposition certificate will be given to the individual. So when you have cases of infringement, you can always show the dates and whatever title of work that was deposited at the copyright registry. Then we go to, still on the copyrights, we'll talk about the power of the copyright officers. So for example, where you have issues around infringement, when you go to the Federal High Court, you would find copyright officers who are actually there to prosecute issues around infringement. You also have collective management organizations who act as collectors for works relating to performances, that is related rights in the copyright space. For copyrights, it's 50 years plus the lifespan of the author. That is 70 years plus the lifespan of the author, please. So you now have the Patent and Designs Act 1970. Like I've explained a whole lot about patents, it has to do with your invention. And Section 13 of the Act says for you to be eligible for registration, it has to be new, not it has to be new, inventive. And like I've explained, for patents, you have to test the state of art. So sometimes, because we don't have a substantive registration system in Nigeria, just say, oh, just file. No. So for example, if you have someone who wants to file in the EU, in the US, they will have to conduct prior art searches to know the state of the art in Nigeria. Same as the Designs Act. This Designs Act promotes innovation and creativity, and it also applies to industrial application. It has to be industrially applicable. So for some jurisdictions, like I said, if once it's more than 50 pieces, they'll tell you to go to industrial designs. So basically, the foundation of that is because of the industrial application, because you have a whole load of pieces. So, and it does not have to be considered immoral or contrary to public policy and order. And for you to be able to file a design, you need a whole load of documents. So for example, when you are filing your design, you have to ask the applicant will have to give a power of attorney, which is called a Form 2 for you to file. You have to file your specifications, which will show what the individual is filing. You have to attach your drawings to the application and also the application letter itself. So in the application letter, you have to show who the inventor is. If they are joint inventors, like joint owners of the designs, you have to mention, oh, this is a joint work, Mr. A and Mr. B actually filing together. And after that, you file either electronically or you file manually at the Patent and Designs Registry. When this is gotten, they'll conduct a search, because the Designs Registry will always have to conduct a search to know whether what you are filing has existed before. So they have to just do the manual search to check the shapes in the register. Has this been filed before? Has this right been given to someone else? Once they see that this is okay, they push it, they examine according to Section 13. Is this new? Is this considered immoral or contrary to public policy or order? If it is not, then they'll give you your certificate. And every 5 years, once they give you the certificate, it's for 5 years. The next 5 years you renew, another 5 years you renew, and that is it. The lifespan for a design is 15 years. Then we go now to the trademarks. The trademarks, like I said, I've explained everything around trademarks. You've all heard trademarks. So when you are filing a trademarks also, they have to give you, the applicant, or if you are filing on behalf of the applicant, always have to give you a Form 1. Once you get the Form 1, it is always advisable to conduct a preliminary search. So preliminary search is saying, oh, the name of my product is Minky, and trademarks are divided into 45 classes. So the first class 1 to 35 is for goods, and class 1 to 34 is for goods, class 35 to 45 is for services. So let's say I want to file Minky in class 36, that is for financial services. So if you want to learn more about classification, I would advise you to go online. You will see the NICE classification or NICE classification. It will state all the general headings for goods. Then you now have the specific classes. You can check the trademarks regulation at the back. You will see the general list. So sometimes when you are filing online, once you click, it brings out all the lists. And this is how, for a lawyer, you have to be very careful. So if I'm in the fashion industry and I said I want to file a trademark, and you file my trademark in class 36, you've done a whole load of damage, because trademark classification is very, very important. Your protection is tied to your class, except if it's a well-known mark in jurisdictions that recognize well-known marks. So for fashion, it's class 25, shoes, clothing, and some, maybe the products in relation to laces and all that will go under some class 20 and all. So if I want to file for a fashion line, I'm filing in 36 for banking. That is a whole load of damage to the client. So you have to know your classification off your head every day when you wake up. You have to sing with it. Class 1 is chemicals, class 2 paint, class 3 cosmetics. That's how you get to learn. It gets to stick in your brain. Sometimes they are confused. One client, 10 products. How do I fix in these classes? That is where you go back. Oh, what edition do we use in Nigeria? 9th edition. Download it. You go through each of the edition one after the other. Okay, sometimes some products is also in class. Like, for example, you have related classes. Class 29 relates to poultry, dairy materials. Class 30 relates to rice, flour, and all. I can have a business and my product will fall under 39, 30, and maybe it's a restaurant business or hotel or wherever, and will fall under 43. Then you file under 30. And when there's an issue, somebody is using the same name in 29, you want to fight the person based on class 30 for 29 to not work. So they will always tell you whatever you do in a classification is very important. So sometimes if the client doesn't want to spend the money, take the time to explain to the client to say, this is very important. You cannot file only in one class. You have to file in all these classes. These are the classes that are relevant to you. So for example, let's take a tech company. You have a digital product, which is a mobile app, which will fall under your class 9. That is downloadable computer software. That will fall under that. They are doing business. Class 35, even though it has to do with advertisement and general business, is a related class. I will file under 35. Then what is this software doing? It's a financial product. It relates to maybe lending, maybe credit, checking for credit risk, lots of that. You go under financial 36. So like when Chinasa said you have to be very analytical, a lot of times, sometimes you see 3 hours, you are tired, you think, no, this class is not it. You go back again and check. Your classification is very, very important. That is like the foundation. Then from there, you conduct your search. Minking class, whatever is registrable, you put in your applications. And what are the things you need? You need the name of the applicant, the address of the applicant. You need the goods, the class also. Then you need to put in your classification. The registry will always ask you for your own address and where your name, whoever is filing now, you even need to put your Supreme Court number when you are filing. So they are actually trying to reduce the results where people who are not lawyers are filing applications. So sometimes when you are filing on the platform, you have to put in your Supreme Court number to say, this is the lawyer who is filing my name, this is my Supreme Court number, this is my address. You tie it together, then you attach the power of attorney that was given to you. If you are filing a device, you attach the device, submit, and after that, you wait for the search to be entered at the trademarks registry. Once it's entered, it moves next to an examiner. The examiner will examine the trademark based on section 9A of the Act. Is it do they want to refuse it absolutely or on relative grounds? Is this immoral? Is this similar to what is on the register? Is it similar to a well-known name? These are things that the examiner will look at. If it's similar to something that is already on the register based on section 11 or 13, they'll give you a refusal letter. But if it's not, it will be accepted. And then you move on to get your acceptance letter. Once you get your acceptance letter, for some agents, that is the end. No, that is not the end. Even though Professor mentioned the case recently, I'm trying to remember the case now. It's the 2001 case, which says that once you get your acceptance letter, it is deemed as that you've already done everything that the law requires you to do. But after that, you have to wait for 60 days. After 60 days, if there's no opposition, you apply for your certificates. But within that period of 60 days, you cannot do anything. That's 2 months. You cannot do anything. You have to wait. It is after that you now apply for the certificate. So it's actually a very straight process. You do your search, you file with the required documents, name, class, address, the device. You move into to get your refusal or acceptance. There's an acceptance, wait for it to be published by the Ministry of Trade and Investment. Once it's been published, wait for 60 days, you apply and get your certificates. Trademarks endures perpetually. There's no timeline for trademark. The only thing you have to do in Nigeria, you have to renew for the first 7 years, that is the lifespan. After 7 years, you renew every 14 years. In some jurisdiction, it's 10 years, but in Nigeria, it's 7 years, then 14 years. Every other time, you have to renew after 14 years. Then we have the trademarks regulation. The trademarks regulation is actually very detailed. It talks to you like from regulation 50 to 70 something. It's all on the processes for an opposition. So if you have an opposition, what do you do? What are the rules of evidence? Am I going to go through the Federal High Court rules? You start from your trademarks regulations. What are the rules? So you have loads and loads of rules in that regulations. It tells you the things to do when you have an opposition and other matters. It talks on assignments, it talks on licensing, it talks on oppositions, a whole lot of things are there. The Merchandise Marks Act is a very old act. It deals with counterfeiting, basically. So when you have false, misleading, or deceptive goods on packages, and it's actually something under the prosecution for, this is actually like something within the jurisdiction of the police. So sometimes when you see them prosecuting people for anti-counterfeiting, they have to go through, sometimes they go through these acts. But the act is old. The penalties is actually minimal. So a lot of people don't really sometimes go through it, and it's also criminal. Then you have the Trademarks Malpractices Act. That is in relation to weigh, measure, weighing instruments and others. Then you have your cyber crimes and the Cyber Crimes Prohibition Act. Well, why this is very important, because it talks about cyber squatting. So cyber squatting is a situation where you make use of a name, business name, trademark, domain name. So for example, I mentioned a company who has not done a lot of business in Nigeria, but let's say they have very good goodwill. Then because you've gone to trademarks registry to check, oh, they're not even registered. When I will just register a domain name or something similar. So once they come to Nigeria, they will not be able to use it .ng.com and all that, not knowing that they already have maybe a trademarks registration, a well-known mark somewhere, and they're able to persuade the courts. So these are things that are very, very, very important. Even trademarks, hijacking people's trademarks, registering, because they are not registered in Nigeria, you just decide to hijack it. when you are not a trademarks owner. So most times the trademarks registry, so it's something to be tested. It talks about anybody who claims to be the proprietor. At this stage, you cannot actually claim to be the proprietor of the mark. We have the Counterfeit and Fake and Wholesome Processed Foods Act, the Plant Variety Act. We have the designs rules and patent rules. So these are the designs rules and patent rules are actually administrative and professional procedural guidance that help the implementations of the act. So sometimes they don't have like the procedure. That's where you have your forms. So if you, for example, now you want to file trademarks and you want to file assignments, maybe a mark that was filed in 1976, and you need to file the assignment, which is obviously manual. What form am I going to use for my trademark? Form 17, Form 16. You have to know all these forms. You won't go and carry Form 22, which is for change of name, to file on Form 17 or 16, which is for maybe a merger and acquisition matter. They would query your applications. So it's through these regulations, you see the forms at the back. You are able to know the forms. These are things that you should learn on your own. Just these acts, these regulations are on online. You can pick them up and go through them. I've mentioned the deposition of work, the NERC system, which is very still well. People can actually deposit their work for themselves or other individuals. I've already mentioned the process of trademarks registration in different classes, and I've explained all these processes. So I think I'll just move on. For registration of patent, when you're filing, you have to look through, ask questions, how invent, what is the state of art, prior art. If the client does not have money because there's a substantive examination here, you can always check online. And also for sometimes you can, the WIPO has this inventors database, they have this global database brands where you can easily conduct all these searches to know. There's a WIPO publication, which is always, I think, online. You can easily check all those things to know. So sometimes it doesn't have to be getting like offshore advice for this. Then for patents, you always need your complete specification form, which states everything. Like you have to get your Form 2, you have to get your complete specification. These forms are in the regulations where you can just fill it. So it's complete specification form, like Prof said, is like the specifications of the inventions. What is the workability of these inventions? You have to explain it. Then you also have your claims. Your claims are like the core of your invention. What is it that you're inventing? You have to explain a whole lot. Maybe sometimes when people file PCTs, you get to see 70 pages documents, but you always have an abstract, a 1 page or half page that would explain what the invention is. So the trademark registry will expect you to file your power of attorney, file your abstracts, your claims, your complete specification forms, the invention itself with the drawings. If it's going through the National Patent Corporation route, if you're entering a national face patent, it's something different. You now have to start asking for international search reports, opinions, if they have, publications, if they have. So these are like different routes for doing this. Exactly like I mentioned, for industrial design, a written declaration if there's a priority. So I need to explain this. For trademarks, currently the Paris Convention and TRIPS and all that we have not been domesticated. So we actually have priority in Nigeria, but the list of the countries where these priorities can be claimed are supposed to be published by the minister, which to date has not been done. So the registry is very reluctant, even though the Paris Convention is there for priorities, very reluctant to issue certificates with priorities. But for patents and designs, you can. So priorities is saying that I've filed something in the UK under the Paris Convention system within 6 months for industrial designs, 12 months for patents. You have to file it in the country you are seeking priority. So if I file something in the UK, October, this is April, I'm supposed to file for trademarks. We don't have it, 6 months. I'm supposed to file it within that 6 months. If it's patents, within 12 months. So priorities are very important. So you don't just file and leave it there. you have to go back to your client to say, the time is going, I need to file this priority, because once it elapses, that is the end. So what are the regulatory agencies in the IP space? We have the Nigerian, I won't say regulatory agencies, maybe like agencies or MDAs, ministries, departments, and agencies though. You have the Nigerian Copyright Commission, the Trademarks Registry, Patents and Designs Commission. FCCPC, very, very, very recently, you have under, I think, 128 or 138 that talks about using false and misleading marks in the selling of products. So most times, for consumers, the complaint has to come from the consumer, not the brand owners there, but it is something that people still, brand owners can actually still talk to consumers about, saying, well, if consumers have complaints, they can go to them to say, I thought I was buying pink, but the pink is not pink enough. It was fuchsia pink or something. Is a very, very, very complaint. You have the NAFDAC, you have your SON, customs, also because at the borders, you have lots of counterfeits coming in. Even though we don't have a compulsory recorder system for customs here, the customs still play a very good role. Funny enough, the EFCC Act also has the definition of IP infringement. The EFCC Act talks about cases of counterfeiting and IP infringement. So these are like agencies that you have. They will now talk about, I think we don't really have time to talk about international IP conventions today, because I think we have just about 4 or 5 minutes left. Maybe in future conferences, we'll be able to talk about the PCT system. These are systems that lawyers should know, because we have loads and loads of work leaving Nigeria every day to this foreign country. So you need to know what the TRIPS agreement is, the Berne Convention, OAPI, RIPO. These are associations, organizations, or treaties which Nigeria has not assented to. Like OAPI now is just one registry for 16 countries. So you have somebody who wants to file something in Ivory Coast, you can't go to a registry there, because there's just one registry, which is in Cameroon, which covers all these areas. So these are things that lawyers have to know. And I know Prof has talked about the challenges. These are the international conventions and treaties we have. So you have the PCT system, WIPO Treaty, Beijing Treaty, the TRIPS, and all that. So thank you very much, everyone. And it was nice talking to us today. Thank you.
Yeah, thank you very much, Simi. That was a really comprehensive delivery. You talked on so many issues. Unfortunately, because of our time constraints, we'll not be able to take all the questions. So I'm just going to take one so that it doesn't appear that we didn't take any questions, and then we'll round up because of time. Somebody has asked that how do you register a mobile phone app do you register a mobile phone app as a patent or a trademark?
Well, that's a very interesting question, because there are different rights that inures in that mobile phone app. So for example, the name of your app is Simi. That's the name of your app, and you're using the app for, let's say, e-commerce. That's like the most common. So the name, that name Simi, the brand name, the name of your app, you register it as what is it now, as a trademark. Then there are soft codes, that source codes that you used someone used to create those the mobile app. So under Copyright Act, source codes, such computer programs are regarded as literary works. So you can just maybe do I would not advise anybody to drop their source code, because that's your lifeline though, but you can actually look through maybe an explanation of the whole process of how you got the mobile app and all that. Your source code is usually like your trade secrets. So that is another form of IP. So whoever is creating that source code is assigning the IP rights to the company who owns the e-commerce business, and signing a confidentiality clause. So if you want to deposit a work, you can just explain all the workability and all that. The user interface, which is the UI UX, how you click the all buttons around. In some jurisdictions, it will come around as a lesser patent. So for example, in the US, you have a category for business patents registration. So you cannot just, they call it like, some jurisdiction will call it utility patents, which you don't have in our laws. But in the US, you have like a category for business patents. So you have like category 30 to 036. So for example, if I want to register a mobile app that uses advertising, I can register that particular way of doing the business. Maybe my e-commerce business is not just pressing the phone and getting the goods at my place. It could be through an escrow agent. I make payment, the money goes to an escrow. At the end of the day, the escrow will pay the final buyer or something. It's a method of doing the business. So something like that is incorporated into the app, and I want to register that method. So I can register it under e-commerce, advertising, like that. So there are like different things. So most times there's actually nothing, if you're looking at the state of arts, there's actually no big deal with the mobile device or mobile app because there are loads of it, but there could be a method of doing the business through the mobile app, which in jurisdictions like US, you can register a utility patent or lesser designs. So you could have your copyright, your trademark, your UI UX for your industrial design, a lesser patent for the mobile app. Thank you.
Thank you very much, Simi. I'm sorry we can't take any more of the questions. They're quite a number, but I can assure you most of these questions started coming in from about 3 o'clock, and I think you addressed them in the course of your presentation. I'd like to say a big thank you to the entire faculty for yielding of themselves and making themselves available for this series. I'd like to particularly thank Inter-Epichem for facilitating this entire series. Special mention I would like to make for the speakers who have yielded of themselves. Professor Bankole Shodipo, who took the first day, Mr. Bafemi Agaba, who took the second day, and to Chinasa and Simon, who have taken the sessions for today. We're very, very grateful and thankful to you. What you have given us, we cannot pay for. We hope that God would compensate you in one way or the other. We're really grateful. On behalf of the ICLE committee, I thank you all. To let you know how impactful this whole process has been, as at 4:45, we had over 5,585 people online, both on this platform and on the YouTube platform. So you can imagine how much and how far this has gone. I'd like to inform you all that the series continues next month. Starting from the 4th of May, we'll be taking the criminal procedure training. It's a 12 series that we're going to take in May, and we'll be talking about criminal procedure training. The faculty include justices of the Supreme Court, EFCC prosecutors, criminal defense lawyers, and other people that you would find quite interesting. These trainings will take place on Thursday, Friday, and Saturday for the 4 weeks that we have in May. Altogether, there will be 4 sessions, Thursday, Fridays, and Saturdays, starting from the 4th of May. Please look out for the flyers. Thank you very much for your time. It's been an utmost pleasure hosting this event. I look forward to seeing everybody around. Enjoy the rest of your day. Thank you very much, everyone.